any of you joining us for the very first time, Tushar is going to introduce himself in just a minute. But for those of you who don't know and haven't joined before, we talk about very serious subjects and it's content rich, but we do like to have a little bit of fun as well. So I also want to know, as people are coming in, because I want Tushar to have everyone here when he introduces himself, where were you on Monday? Where did you see the eclipse? We'd love to know. So you're welcome to put that in the chat, and we can see where you were seeing that from. In my
Nice, Amy.
office live streaming, I love that, Amy. I'm sure it was still amazing from the window in Kitchener. That's great. Lake Erie. Well, I want to tell you all that I was in Durham region at Trail Hub, where there's this amazing look at, and I thought, oh no, we're never going to be able to see this. There's too much cloud coverage. And voila, the clouds broke just enough that we could see some of it. I see Burlington. Oh, Burlington's wonderful. Oh
Oh
no,
yeah,
too
Amy,
many
I
clouds
actually
in
was out.
BC.
I was out in
Where were
Hamilton,
you?
so
And did
we.
you get to see it?
Oh yeah, full occlusion. It was surreal, and we actually. So one of my partners here at Gowling is the president of, I believe it's the Royal Astronomical Society, and so we had a full on prep session, let's call it, for the eclipse.
Wow. Yeah.
And he was pushing, make sure you're getting your goggles, make sure you're getting them in advance, get the ones for your phone because it'll burn out your phone.
Oh my
So we were
gosh. Well,
eminently
yeah, I
prepared.
didn't try to take pictures. I'm like, someone somewhere is taking a much better picture of this than I will ever be able to, right?
Oh yeah.
It's good that you had the education as well. So that's great. I see. So I'm sorry to hear. I saw Massimo say that he didn't get to see it because it was overcast. But a lot of people seem to have zipped out of work to go to the parking lot. But I hope you all had a great time. So Tushar, now we might notice that we're one person short today. Sadly, Nina had to be in court, but I thought it's going to make everyone feel really good to know that she would prioritize a court date that came up suddenly over joining the Coffee and Law. So we
Yes,
have
indeed.
Tushar.
Yeah.
And Tushar, do you mind if I share your exciting news?
Yeah, for sure.
Yeah, Tushar was promoted to partner. What was it? Or you were made partner late last year, right?
January 1st was the official
January
date,
1st. So
and
you
yeah,
you
I
got
found
some
out late
applause.
December. Yeah, early Christmas
So
present.
deserving. Isn't it so nice to see
Thank you.
when the people in your network who really deserve the promotions, the accolades, get them. So I'm very, very happy for you, Tushar. But I want to give you a moment to talk about Gowling and your work.
Thank you so much. And Amy, I really always appreciate the time that we get to spend together, and I'm sending a heartfelt from Nina. She specifically
Uh,
asked me to do that. So here we go. We're ticking boxes. So Gowling is a full service firm. For those that haven't dealt with us before, I'm part of our employment, labor, and equalities group, and our focal point is on any HR related issues, and we're going to talk about quite a few of them today. I will say one little bit that I'm legally obligated to say. This is not legal advice. What you're hearing today is general information, and if you do have a specific harassment, discrimination, bullying, etc. type situation that you're dealing with, I'd be happy to help, subject to conflicts, and or one of our professionals at Gowling would be happy to help out as well. So yeah, any specific advice, please feel free to pick up the phone. I'm always happy to chat.
Great. And I know you have a special mug today. It is our Coffee and Law. Did you wanna show it to us?
Yes, I do. Actually, this one was a gift from one of my dear clients. I don't believe
Can you hold it up
Katie has
higher?
been able to make it, but this is a Yeti. Oh, if my blur will cooperate, it's a Yeti in a
Yes.
beautiful burnt orange color. And yeah, I can tell you that it's fully loaded, and I'm going to be buzzing by the end of this hour.
That's great. Well, people have seen this mug before. It's my London Big Ben mug. So it's going to be a full hour. So I have to have something that is going to carry me over for that hour. So there you go. So
Love
thank
it.
you, Tushar. And I know that you wanted to we wanted to wish everyone a happy Eid who's celebrating.
Absolutely. Yeah. For those that are celebrating today, there's some that are celebrating today. I believe there's some that are actually celebrating tomorrow. So either way, Eid Mubarak to everybody, and yeah, happy Eid, and I hope you guys have a wonderful celebration, and cheers to the new year.
Yeah. Thank you, Tushar. That's great. Now, I want to say that as a housekeeping note, we will be sharing a recording of this presentation within about a week or so. So you will get that in your inbox. Someone asked for sharing the slides. You will see that those slides probably aren't worth sharing. There's not many of them, but we will definitely send you the recording of this session we're recording right now. When you ask your Q&A, please make sure that you can put that in the Q&A. You can also ask anonymous questions. I know that we're covering a difficult topic today, so if you need to ask questions that you don't, and try to make your questions. Sometimes people put a lot of context in their questions, and it can be hard for us to read that while we're running the session. So try to make your questions, it's difficult, but as succinct as you can, because that will make it a lot easier for us to answer them, especially considering there's two of us here today. Usually when we have a third and a second lawyer on the call, we can go through those a little in more detail. And Tushar, you're great at often answering them on the fly and typing away. And we don't have that luxury today. So that would be so helpful. A little bit about First 30, for those of you who don't know, we specialize in employee onboarding and outplacement. So if you are running layoffs and you need career transition support, we offer a fantastic solution that's incredibly cost effective. We're now working with larger and larger clients who are taking us on as their second provider of outplacement, because we really specialize in the entry and junior level. We can also do executive, but sometimes they'll take us on to save a bit of money and get an exceptional experience for their employees. So you're more than welcome. I know Camara is in our chat right now, and she's going to put the brochure. Oh, I see she's done that already. You can download a copy of the brochure, and we're very transparent and consistent with our pricing. Our results are fantastic. Camara is also a big part of the program and the participant experience. And we do have a very high success rate in getting our participants back to work quickly. We also have a super exciting thing going on with our onboarding solution right now. We are trying to identify clients who will work with us and give us feedback on our dashboards and all of the new things that we're building onto the platform. And for that, we are gifting the platform to you. So if you want to work with us with no setup costs and no commitment, just the price of your feedback, we would be so happy to work with you. I know Camara is going to put in a link where you can book some time with me or email me about that. Now on to our topic. So this is a tough one, I think. It's one I feel very passionately about. Tushar, I know I've had lived experience of being, I would call it bullied in the workplace for sure. And it did play heavily. It really weighed on me heavily. It was something that I found incredibly, incredibly stressful. And it's so wonderful when you have great HR leaders who are there to support you, to work with organizations like yours, Tushar, and lawyers to help run thorough investigations. About 1 in 3 people have claimed to be bullied or harassed. And I say claimed, they have been bullied and harassed in the workplace. I believe that number is probably higher, actually. I think this is reported, and a lot of what happens, as we know, goes unreported. I would recommend this book. I read it years ago, and I always reference it because it was amazing. It's by Dr. Robert Hare. Have you read it, Tushar?
I haven't read it. I've thumbed through some of the key excerpts because this got a lot of conversation when it made it to Amazon, and it was on Kindle, and a lot of people were flagging this as a must read. They have their must read list, but yeah, absolutely.
Yes. And one of the things, so Dr. Robert Hare is a Canadian criminal psychologist, and he created the psychopath checklist, which is very commonly used in court, actually, and to assess criminals and criminal behavior. He estimates that 4 to 5% of the North American population are non-murderous psychopaths. So I'll let you sit with that for a minute. It's scary, and people often laugh when I say it, and I laugh a little too because it seems outrageous. But it is. We have interacted with these types of people, and a lot of times when we have cases of harassment, severe harassment in workplaces, we may be dealing with this type of personality dysfunction. So something to consider, a great book to read. And I'm sorry if you have ever been through this like I have. But anyway, I know that's not exactly what our session is about today, but it's just to reinforce the importance of this topic. And it's certainly one, as you can imagine, that's very close to my heart. Okay, so with that, I'm going to pass it over. Now, we have some questions to get us started, but I actually noticed that we already have a question in the comments. So I'm going to just jump to that, Tushar, and then we have some more questions and I'll also ask those. So if you do have a question, please put it in the Q&A and we will answer that. So this person says, it's an anonymous attendee, so you can see you can ask these anonymously. I've just completed a harassment investigation between two employees that were briefly romantically involved. Are there any best practices you can recommend to put a relationship in the workplace policy that are legal for us to do and can hopefully help avoid a similar complaint in the future?
Definitely. I mean, one of the first things that comes to mind, because we're trying to avoid situations where the wheels fall off and there's substantial liability, right? That's a standard mode of thinking for a lawyer. And so what are we doing with current relationships in the workplace is one of the first things that comes to mind. Because if implementing a policy actually threatens to, effectively remove someone from their position of authority or reallocate resources or remove a direct report, we could be dealing with a potential constructive dismissal type situation. So the first thing I think, rather than taking a step forward, is just to take a step back and assess what's going on, the things that you know about. There might be a completely functional husband and wife duo. We might have worked in workplaces where this is common. In law firms, believe it or not, it's actually quite common. We spend so much time.
What?
Oh yeah. And look, it's not just law firms. It's not just law firms.
Yes.
Any workplace really. This is something that comes up from time to time, and I think in terms of the policy itself, I mean, there are multiple resources, including retaining a lawyer to draft or ghostwrite the policy with you. But there are third-party services that can provide you with at least a starting point for this type of a policy. In terms of best practices, I mean, we want to be mindful that if there is an ongoing investigation that's just concluded and confidentiality has not been strictly adhered to, there might be a perception as well that we're doing this directly in response to this particular case. So if this romantic investigation situation involved like 15 witnesses who watched something happen at a Christmas party, and then all of a sudden we're introducing this policy, they might link those together. So perhaps even buffer it a little bit. Sometimes time is your friend. And obviously the business, it seems like in this case, has gotten to this point without a policy. We're introducing this. We need to be prepared to explain why in a way that doesn't specifically target the existing relationships or the individuals who are involved in this harassment investigation. Hopefully that somewhat covers it off, but thanks for the curveball, Amy, right off the
I
bat.
know. That was a really good first question. And that is such a
Absolutely.
complicated one, right? Because on top of everything else, people have relationships at work, when they're younger, when they're older, but, remembering back when I was young in the workplace, that is often where people meet their life partner too, right? And as you were saying, in law firms, it's quite common. In a lot of workplaces, you spend a lot of time with these people and you become close, right? It's natural for that to happen. So thank you for that question. It was a fun one to start off.
Absolutely.
We are happy to take any more questions, so feel free to put those in the Q&A. We do have some as well that were sent in. Now, Tushar, this is a kind of complicated one because we have these health and safety acts and all of these policies for the workplace and the people who are in our workplace. Do we have policies that extend to people who are volunteers or people who, for instance, are not on the payroll?
Yes, for sure. I mean, so there is a provision under the Occupational Health and Safety Act in Ontario. Let me just start there. I know that there are people who are on the call who might not be in Ontario or who might be joining from the United States. So the first point of reference is check the laws of your local jurisdiction. Make sure you're getting specific advice on that, because in some instances you may be required to include volunteers in specific cases, as part of your harassment facing policies, right? So we want to check there first and make sure that we are not statutorily required to treat these people like employees. Let's assume, for sake of argument. Oh, by the way, in Ontario, there is such a provision in the Health and Safety Act for provincially regulated employers, and the provisions effectively go through a form of a legal test to determine what type of volunteer is it. Is it someone who is, a board of directors member, where there is perhaps a greater likelihood that this person will be captured in the harassment policies because they're likely to be treated as a worker or an employee under the Health and Safety Act? Or are we talking about someone who came in to, help distribute lunches to the school on one occasion, and we've never seen this person ever before, probably won't see them again? There is a contextual factor that feeds into this. But okay, let's assume, for sake of argument, that there is no such contextual legal test under the relevant legislation that governs your entity. What is stopping you practically? And maybe this is a question for your legal counsel if you're in a non-Canadian jurisdiction. What is practically stopping you from introducing a policy that actually requires your volunteers and those individuals, so spouses who are coming to Christmas parties, individuals who are not directly captured under the definition of worker or employee, from adhering to a code of conduct or a standard of behavior, whereby we are actually protecting our staff? Practically speaking, in Ontario, there's not a lot that actually stops an entity from creating these codes of conduct, from enforcing the policies, so to speak, and potentially removing, if it's a board of directors member who's abusing authority and bullying someone, or another individual of that sort, from their position. Right? I mean, there is the ability to layer on top of the baseline that is formed by legislation. Hopefully that answers the question.
Yeah, it is that. I mean, these are both, I feel like everything related to this topic is going to be complicated, but that is particularly complicated, right? Because as you know, you're saying these are volunteers on boards as well. And it does add to the complexity of everything else that we're talking about, right? And how do you protect your employees but balance the rights of everyone involved? And of course, there's going to be laws, like not just laws, not just policy, but actual law that is going to cover some of the behavior that we see happening at things like parties and whatnot. We have a question in the chat here. If harassment has occurred within the 3-month probation, but it looks like it was with the client only shared this information after the termination, what can be done as the client claimed they were physically assaulted by their leader or supervisor by means of it looks like they were physically assaulted. The client does not want employees to be fired, but hopes for a change in the future for others.
How do we keep that relationship alive knowing that that's happened, right? And I think,
Yes.
yeah, that is very difficult, because so let's look at a specific example. If this is in Ontario, right? If this is happening in Ontario and it's come to our attention that there was a physical assault, which is, I'm going to the criminal code, right? That's a criminal code offense, and it's come to our attention, and we have one side of the story. And we want to do something to correct this. I think it's incumbent upon an employer. I mean, they're statutorily obligated to take every precaution reasonable in the circumstances to keep the workplace safe. And so, in my view, I mean, when we find this out from the client, we're on rails here. We are obligated to conduct an investigation that is appropriate in the circumstances to figure out who, what, when, where, why, how, and if there is substantiated harassment or assault in this case, then what are we doing to correct it? And so I think it perhaps is a little bit, let's assume it's substantiated, right? We've got a situation where someone physically assaulted somebody else. The person may not have brought forward a complaint out of fear or any other reason that you can think of, Amy, for the suppression of a complaint. And now all of a sudden this comes to light through a third party. I don't know that we can salvage this particular relationship, right? I mean, do we want this to happen again? And are we opening the door by simply providing a warning or something along those lines? These are the types of cases that typically, I mean, we don't. Let's look at it this way. If we were if we were to execute something less than a very firm response, and this story were to end up on the front page of the Toronto Star, how would you
Yeah.
feel? And what
Yeah,
would
and
that
that's you
reflect
have
on the
to think
business?
about that all the time,
Mhm.
don't you? And it's not just the front page of the Toronto Star, it's on social media. It can go anywhere. And we were talking about I obviously deal a lot in layoffs and terminations, and we're seeing examples of people filming their termination and
Oh yeah.
putting that on social media, right? So there's a
Nina
lot that
was
can
just
happen.
actually talking about that with a
Oh.
reporter from the Toronto
Yeah,
Star, and
yeah.
it's one of those things. And why don't we, I mean, it could happen in the context of a workplace harassment investigation. And
Hmm.
so, is maybe we can go there, Amy,
Hmm.
or
I know
do we
that
want to hold
Carrie,
here for a second?
yeah, we have someone who has their hand up and we can allow you to talk, Carrie. So why don't we try that? We've never done this before. You would be the first one on a Coffee and Law Q&A. So Carrie, I'm going to make you live. And I just wanted to say one last thing before we move forward. There was just the last point on this person's question that there's also concern about dealing long-term with the employer, but they want to move forward. So that was just something I would add in case it makes any difference. But Carrie, I'm going to allow you to talk. So Carrie, you're on. You're muted, but you're on. Oh, you have to go off mute, but if you don't want to, that's okay. I will, I'll ask you to unmute, but if it doesn't work, we'll stop that. Okay. We will,
We can always come back to
yeah,
that.
we can always come back, Carrie. Or you're welcome to put your question in the Q&A. So Tushar, why don't you move on with your second piece that you were going to talk
Recordings,
about?
definitely, yeah. So what Nina was talking about with this reporter from the Toronto Star is the recording and posting of termination meetings and whether or not that is legal and what the possible repercussions could be. The same thing could, in theory, happen in the context of a workplace harassment investigation, right? In some cases, policies, collective agreements. There's nothing under our laws, but there may be, depending on the jurisdiction that you're joining us from, um, there may be a requirement to actually record, audio record or video record this specific type of an investigation. So if that is happening, then that's one thing. That's one thing. I think what we're contemplating is, an individual, whether it's a witness, the complainant, the alleged harasser, bullier, or the person who's alleged to have been violent, they're coming in and they're saying, I'm not participating in this meeting unless there's a recording, right? And
Mhm.
in theory, I mean, there's nothing really that stops that person from doing that, at least under the confines of the Ontario Occupational Health and Safety Act. And so, generally speaking, I mean, one of the things that I recommend doing, because we want to proceed with the investigation, right? In many instances, these folks are off work on a form of a paid administrative leave. So they're on
Mhm.
garden leave, accruing service. This can go on for weeks and if not longer. So we want to get this done. More often than not, what I will recommend is to simply turn on your recording device and participate in the recording, and just to make sure that everybody's all on the same page so
Oh,
that we
okay.
have access to that and they have access to that. And
Ah,
so
that's a good
one of the
idea.
things we've got to be mindful that these investigations, they're never, there's the number of criticisms that are made of investigators, but going too quickly and finishing the investigation too quickly is never one of them. They want to be
Okay.
mindful of the fact that they could be called as a witness in court, and then they have to back up the investigation process, right? So
Yeah.
so that is all. It could be evidence. Any of the stuff that you're talking about with this particular complainant, harasser, et cetera, could be evidence. And in many ways, there's no better evidence than a straight up recording, and whether
Hmm.
one party puts it in or the other one puts it in, depending on if it goes anywhere,
Yeah.
it could be before the court. So one of the things that frequently comes up as well is, okay, audio versus video. And oftentimes that's a negotiation. And so a lot of companies, they will have a hard and fast policy that says absolutely no video recording during a workplace investigation. And I think that's all for the best, because there are sensitive issues and items that are shared during the course of an investigation. And maybe we don't want the person's face and all of that stuff so that it's directly identifiable. And they will push for, okay, you know what, we're not going to do video, we're not willing to do this. We will specifically, oh, thank you, Joshua. We will specifically talk to you about an audio recording and making it work with an audio recording, whether it's one side or both sides. So there's a, as you said earlier, Amy, it's like unfurling an onion. There's
Yes,
so
it
much
is.
there.
And I don't think a lot of people are aware that in some states and some provinces, it is legal to have a one consent recording. And so if you and I, Tushar, were, at an event and we had a conversation, I could record that conversation without you knowing, and it could be admissible in court. And I'm not the lawyer,
Correct.
but I'm talking like one right now. So I know just enough to be dangerous. Correct me if I'm wrong. But
No,
it
you're
does,
bang
there's
on.
the different laws. And I think Joshua put this up in the chat for the US to say which states are all party consent versus one party consent. That's actually a really important point for people who are being bullied and harassed in the workplace, because you could technically record the harassment that you're experiencing legally, and that would be admissible in court. And I wanted to add something to this, is that there's also, you would know, Tushar, and this was kind of a question that sprung up, and then we have another one in the chat that I'm going to come to, but you had mentioned the workplace and the policies in the workplace. Can an employer legally put in a workplace policy that you cannot record conversations in the workplace, even if you're in a province or state? You might not know this for every province or state, but talk about the ones you do know. If you are in a province or state where you are allowed to have one party consent, does the provincial or state law override the policy of the employer?
That's a good question. And I think that's probably a takeaway, Amy, because that's a pretty niche,
Yeah, yeah,
question, right?
yeah.
So to look, shooting from the hip, right? And without the benefit of researching this, I don't think there's any prohibition against implementing some sort of a company policy that says exactly what you just did. And in my view, even if there is such a prohibition when it comes to, everything's hitting the wall and we're at trial and can we rely on this recording or not? Is it prohibited or not? That's all over here, right? We
Yeah.
exist 98% of the time, we exist over here. So do we want to establish and deter this from happening? Absolutely. Do we want people running around surreptitiously most of the time recording? Like if Amy and Tushar are having a coffee, right?
Yeah.
And Amy's surreptitiously recording this conversation, do we want that type of behavior? It's a it's like a stab in the back almost, right?
Yeah.
If there
Yeah.
is something that comes to light. And I've been
It's a
involved in
huge
cases.
violation. It's a huge violation when you don't know you're being recorded. Now, your behavior might be such the person is fearful of you and they're doing it to protect themselves. So
Mhm,
there's something understandable about that. So I don't want to take away from those types. But if you
for
and
sure.
I are friends or we have a good relationship or working relationship and I'm recording you without your knowledge, that does feel like definitely there's a violation there. It may not be a legal violation, but it's certainly an ethical violation between the two of us.
For sure. And I've been involved in cases where these issues have come up, and the individual in question, either during the course of the investigation or at some point thereafter, has tried to make hay out of a recording that's happened, and
Mm.
it really doesn't play well.
Mhm.
Frankly, the plaintiff side lawyers who are, they're obligated to advocate for their client's best interest. They are also uncomfortable just on a human level,
Mm.
pushing these arguments across and saying, well, in the
Mhm.
meeting that happened on April 9th, which you didn't tell anyone you were recording, it was known that you said X, Y, and Z, and this happened, and you didn't actually stick to the performance improvement plan like you're saying. It
Yeah.
doesn't really play well, particularly if there's a policy in place. And like all policies, there've got to be carve-outs, right? I mean, there are
Yeah.
emergency situations that happen, and nobody wants to push those off the end of the table. It's
Yeah.
this constant running around with a computer in your pocket,
Yeah.
and how do we stop that from happening? In some instances, we don't actually need to deal specifically with this particular subject, you can just say, look, no cell phones permitted on the production floor, right?
Yeah.
And if it's not a cell phone and it's some sort of other spy ops surreptitious recording device, then we can deal
Yeah.
with that at that time. But most people are not going to be watching the spy ops websites to figure out how to get a button camera or whatever in, and they're brutally expensive anyway. So
Yes.
where this will capture 95% of, I would think, these issues.
This is becoming, it's such a big issue too. So I really like this question in the chat here. Are you, because this is something like not a lot of, it's become more and more common for people to be aware of this now, that there are questions that are illegal to ask candidates in job interviews. Again, very different federal versus state or provincial regulations on these things. So I want to call that out immediately. If you have any concerns, it's worth checking. Personally, I think you take the law to the furthest extent, and you've practiced that law. And the reason I think when it comes to interviewing candidates and the questions and topics you bring up, and the reason why I say that is because, and tell me again, enough, I know enough to be dangerous here, but if there is a federal law when it comes to candidates, there is a chance that that federal law could become a state or provincial law over time. So if you're already following the highest level of the law, you're not going to have to do much of a pivot. It's hard to communicate to interviewers and recruiters that things have changed. So the question is this. First of all, you should probably answer that question to make sure I'm right. But after you answer this one, are you aware of any situations where a job candidate has sought legal support after a negative interview experience?
Yeah, definitely. I mean, there are cases that go to the Human Rights Tribunal, they go to the courts, they go to a number of different fora, plural, for these types of issues. I mean, we've got decided case law. There's I believe it's Hasib, which is the one that went to the Human Rights Tribunal, then it went to the appeal courts, and now it's sort of been reversed on appeal. So asking about Canadian experience and the ability for the person to work in within the country, right?
Mm-hmm.
So in short, yes, absolutely. And you know, I will say that it's on occasion, I mean, particularly in executive, contract negotiations, et cetera, we might have legal counsel involved even before the interview even starts, right?
Mm-hmm.
Or at any point in the interaction when you're talking about contractual terms. But yep, if there's something that breaches a human rights code or a federal regulation, whether it's the Canada Human Rights Act or something along those lines, we definitely do see lawyer involvement. It's not mandatory. I mean, the person can self-represent and go before the CHRT on the federal side, or the HRTO in Ontario, or any of the provincial human rights regulators. So
Yeah.
they can self-represent. But yeah, it quite often does happen, and that's why these interview questions need to be bang on with respect to what's allowed under law. And I do like your comment, Amy, going back to your initial. Yes, high watermark. High watermark is a safe practice. If you're adopting the safest practice that's available across the country, then chances
Mm-hmm.
are that you're not going to get it wrong. However, I do think that there is still an opportunity for differentiation between the specific jurisdictions in question. So I'll give you one practical example. Maybe we can go here.
Mm-hmm.
In Ontario, there is an obligation under the Occupational Health and Safety Act to notify the complainant and the harasser, violence person, et cetera, the alleged harasser, et cetera, of the outcome of a workplace investigation. So you run your investigation, you meet with all the interviews, you go through this process, you get to finality, right? Outcome, corrective action, here are the steps that we're taking. That's all that's required, right?
Mm-hmm.
Contrast that with the federal regulations that were put in place. I believe it was last year, but the federal regulations say nope. They're getting a copy of the investigation report, right? Which
Mm-hmm.
is dramatically different from what Ontario requires. So if you are adopting a higher standard on the federal side, you're actually going, I will say, way above what is standard market and required in your jurisdiction here. So it's a
Mm-hmm.
safe practice. I don't think you're going to get in trouble for sharing your investigation report unless the report contains a number of sensitive things about matters that may not even be relevant to the investigation, the investigator's notes, et cetera, et cetera. So I would say uh, best practice, get specific advice on what your policies should be for the market that you're in.
Yeah. Okay. That's very good advice. And you know what? I know that Gowling releases some really great insight, that you have insights and updates. So maybe Joshua, I assume, is on your team, who's been sharing the links. Have I got that right? Tushar?
I actually don't know Joshua personally.
Oh,
I have to
sorry,
double check.
Joshua. You've been so great at
Oh yeah,
sharing all these resources.
he
Well,
may be. He
maybe,
may be. Gowling's a
yeah.
big place.
You have me fooled there, Joshua. So if if you have a chance to share, it might be worth putting your link so that people on the call can actually subscribe to your the Gowling updates, because oh, thanks, Joshua. I appreciate your contribution there. Any interest in doing employment law on your side?
Oh yeah.
um, so yes, because you do have updates, and I know there are a lot of updates, a lot of changes always happening. And I think one of the hard parts is, and I would add this as, something that to consider is, if you are concerned that the people on your team are interviewing and asking, it's so easy, right? Tell me about yourself. And then the person starts talking about all the things that they're not supposed to discuss. Well, then what does an interviewer do in that situation? And a lot of
Mhm.
situations like that come up, whether it's interviewing or in the workplace. Training is so important. And I know, Tushar, you and I were talking that you do some training, and I think it was more related to workplace investigations.
Definitely, yeah. So we have an election point in Ontario specifically. So if a complaint comes in, um, we are obligated to take precautions and to implement an investigation that is appropriate in the circumstances, right? So the person in HR, or maybe the person who owns the company, or whoever's dealing with that complaint, gets to
Hmm.
choose. Are we going to go internal with this harassment investigation or whatever that investigation may be, or are we going to
Yeah,
go external, right? There
right.
are rules and regulations, particularly on the federal side in Canada, I'll say,
Yeah.
regarding the qualifications of an investigator. Let's kind of leave that on the side, right? So you get to choose. If you're proceeding down this path, you effectively have to evaluate your options and evaluate the circumstances. Check your specific, just being practical here, check your
Hmm.
workload, right? If you're
Hmm.
going to go on vacation in 2 weeks, maybe it's best to go external,
Yeah.
because we have time frames under the regulations which say you've got to do this within a period of, say, 90 days under the
Hmm.
Occupational Health and Safety Act. That's a general expectation unless
Hmm.
there are extraneous circumstances. So what's your capacity? What's your budget, right? An external investigation could be quite expensive,
Hmm.
and effectively, slow down your operation and pause you from doing all the other HR related things that you're doing, if you decide
Yes.
to do it yourself, right? So there's a lot there. There's a lot to consider. And once you're in that role, let's say you do decide to do an internal investigation, you're held to an exceedingly high standard. The assumption under law, when you go forward and have to defend the investigation, is that you've reviewed the Occupational Health and Safety Act, you've reviewed the Occupational Health and Safety Act Code of Practice for investigations, you're adhering to all the requirements regarding confidentiality, and you're somehow aware of all the best practices that have emerged from the common law. Because in Ontario, we have this funky thing called the common law, which layers on top of all of the legislative requirements that we've got to meet. So, are you equipped to do all of this? So, something that I do fairly often is I will run, investigation workshops for specific clients as these needs come up. If we spot a gap and there's a group, then yes, we can actually do that in person, and I'm happy to come out to you. We also have one of my colleagues. I'll pop her profile in the chat here. One of my colleagues locally here in Waterloo, Melissa Roth. Um, she just concluded a very, very in-depth, full day long investigation workshop. I believe this is the third one that they've run, and repeat customers, if you can imagine,
Hmm.
because these issues come up and there are so many little wrinkles that you've got to kind of track and keep in mind. So if you've got a mandate from your policies, or from the powers that be at your particular organization or company, that you've got to do this internally, you do not want to be out of your depth, because setting a foot wrong could result in potentially significant exposure, and your name and involvement in a protracted legal proceeding. Nina, I can tell you this, Amy, the facts and circumstances giving rise to the case that Nina is dealing with today occurred in 2014. right? Imagine
Wow.
having that hang over your head for a
Yeah.
decade while this works its way through the court process. Yeah. So sometimes a stitch
That's
in time can save nine.
Yeah, no kidding. We have a couple more questions in the chat and the Q&A. I just wanted to point out, Tushar, you're amazing. He's talking, and at the same time he's talking, I'm seeing information pop up from him in the chat. So I don't know how you do this, but you did only send it to me.
Oh,
So
sorry. I thought
I'm
I
going to
no,
give you a minute while I'm asking this question. So maybe you can put the details for Melissa, who you were talking about, who runs the
there we go.
investigations, in the actual chat to the panelists.
And actually,
Wonderful.
there's a second one I'm going to pop up too. So it's on our
Okay.
homepage under CASL,
Yeah.
the Canadian anti-spam legislation. We can't
Yeah.
actually sign anybody up for our insights. So if you go on our
Okay.
homepage, there's a specific section that's entitled Featured Insights, Featured News
Okay.
and Insights, and then you can
Yeah.
actually set up your feed. If you want stuff that's relevant to, I'm just going to make it up, the mining sector,
Right.
then you'll get mining sector stuff. If you
And
click
I
on
know we have
employment,
people in
labor and equality,
construction on the call too.
definitely,
So construction, manufacturing. Yeah.
100%.
Okay.
Yeah.
So we have a question here and a question in the Q&A. So I'm going to start with the one in the chat. Can you inform legal considering factors regarding enforcing official language use in the workplace to avoid exclusion?
Can you inform legal considering factors regarding enforcing official language use in the workplace to avoid exclusion? I'm not sure I fully understand.
Yeah, I think what the question is can you ask people to use specific languages in the workplace?
mhm,
So, for instance, if you are in a primarily English speaking place in the country, in either the US or Canada, we have a lot of new Canadians and new Americans who come in and may not, they may be more comfortable speaking in their native
mm,
language, which is absolutely understandable. However, I can see how that can lead to complications in the workplace if you need to have one language between employees in a manufacturing plant, for instance, where safety is paramount, right? Is
mhm.
there a way to enforce that there is a primary spoken language in the workplace?
And what is the cost associated with enforcing that if this again ends up before the Toronto Star on the front page, right? Because
Right.
we're dealing with immutable characteristics.
Yeah.
Someone who is emigrated here, I'm just going to pull, the first R that pops into my head is Romania. Okay. So someone
Okay.
who emigrates here from Romania and has very little understanding of English, and if they're involved in a workplace harassment investigation as a complainant, witness, or respondent, um, and we are enforcing English or French or whatever the languages that we're choosing to enforce, are we suppressing that person's ability to fully participate in the investigation process? More than likely, right?
Yeah.
What is the downside risk associated with that? Depends. It depends on the case. If we're doing this in Quebec and we're enforcing some language other than French, then we could be hauled in front of a regulator and punished under Bill 96, which is that French
Yeah.
Language Law Preservation Act. If we're
Yeah.
doing it in Ontario, it may very well manifest in the form of a bad faith claim, punitive damages claim at common law, a human rights
Yeah.
complaint on the basis of a protected ground. So generally speaking, I think there's an expectation that there will be a level of flexibility. And I can share that I've been at the labor board. We've been ready to start off proceedings, and then we've had to pause everything because the person's from Afghanistan. They don't speak a lick of English. They tried, and it was not working. So then we had to go and source a third-party neutral. I want to focus on that third-party neutral interpreter to come in and provide us with an official service, basically an interpreting service.
Mhm.
So if we're going down that path, the reason I focus on third-party and neutral is because it shouldn't be someone's mother, brother, uncle, cousin, etc. It should be somebody that this is what they do, and they'll more often than not they will give you an official transcript of what they have interpreted, just so that you have something immortalized there for the record.
Mhm.
So I don't know that we want to enforce an official language if it's something that's not regulated by law, such as in Quebec. There are downside
Mhm.
costs, significant potential
Yeah.
downside costs.
Yeah. Yeah. So it's an example where a company's trying to do the right thing to protect people. But at the same time, there's mitigating factors that they might not be taking into consideration. And that's why it's important to speak to your lawyers, right?
And that's a
To
great
give,
question. I mean, this
it
is the
is a
kind of
really
stuff
good
that, you know,
question.
if we can think of it, there's an employee out there that will think of this, right? And even if I've
Absolutely.
had a situation come up where even though they had, you know, pretty good carriage of English, they specifically requested an interpreter in an effort to slow things down because we had a good sense that this was an alleged harasser and that the allegations were substantiated. This was
Okay.
just a delay tactic so that they could stay on administrative leave for another week, right? So be it,
Right. Okay.
right? We want to
Yeah.
protect the
Yeah.
integrity of the investigation. That's what
Yeah.
we have to stand on if the wheels fall off. And
Mhm.
if we are sort of rushing that one through or not doing it according to best practice, then we're potentially putting money in their pocket when they may have harassed somebody or you know, physically assaulted someone or whatever the case is.
Yeah. Thank you. So we have another question in the Q&A, and Barb, I see you have your hand up there. So Barb, what I'm going to ask you to do is while we answer this question, can you just let me know in the chat that you're good to talk? Oh no, she put her hand down. I think people get confused about what those things are for, and I never knew what they were for
I
before
think it's the
either. So I
AI. I think it's the
apologize.
automated hand up animation
Yeah,
on
yeah.
Zoom.
It's like
Someone's waving
you
at
were
somebody
really
else.
meant
Yeah.
to clap, right?
Yeah.
So I'm glad I checked. But we do have a question, and we don't have all that much more time, but we certainly have another more time for a question or two. Can an employee who has been disciplined as a result of a harassment investigation demand to be given a copy of any internal disciplinary forms that they have had to sign, i.e. written warning, notice of suspension, notice of mandatory counseling, etc.?
Can they demand it? Sure.
Mm-hmm.
Yeah, they can
Yes,
definitely
that's a
demand
good
it.
point.
Do we have to produce it? It depends,
Yeah.
right? If we've created sort of transparency policies which obligate us to do this and which actually require us to execute on this, right? So it does happen. I mean, sometimes companies want to do this, or if you're a state employer, a crown corporation, something like that, that's something that your policies, procedures, guidelines, or the laws that apply in your jurisdiction might require. If there's nothing of that sort and the demand comes in, then we have the option of saying no, right?
Mm-hmm.
But I guess what is the purpose of the demand? And again, we're going into context, right, Amy? The devil's in
Yes.
the details. So what is the purpose of the demand? And what do we stand to gain by resisting production? Right? If there's no grand reveal, like if the person's requesting this because their union is saying, hey, we're going to bring a grievance regarding this and you've been targeted or something like that, maybe we do want to resist disclosure and say this is HR property. They'll already have copies of all of this stuff. That's something else to kind of keep in mind too.
Mm-hmm.
But maybe this is HR property and we're not going to cooperate. We do sometimes get these requests in from third parties, so insurance companies, et cetera, that you know, an employee who used to work here 10 years ago is involved in a motor vehicle accident, and we want their whole employee file, including X, Y, and Z, right?
Mm-hmm.
Again, there's without a court order, there's no specific obligation unless you've got a policy to produce all this stuff. But do we then want to have to go to court and defend it? So practicality usually dictates, and if we have nothing to do with it, no downside risk, then we may want to accede to the demand. So again, it's all context dependent, right? That's the
Mm-hmm.
issue here, and we've got to know a little bit more about the discipline and the background facts in order to provide advice.
Yet to provide specific advice. And you did put your email up in the chat, didn't you, Tushar, in case people want to get a hold of you?
I'll do you one better. I'll put my profile up there. I might have just sent it to you, Amy, when my settings were.
We're all learning. It's hard with Zoom. You have all these things coming at you. Now I know I see that there was a follow-up to the English language question. And I just want to see if there's anything more that we can add. If the management team who all speak English communicate in another language and an employee who does not speak the language lodges a complaint, what solutions can we offer if we cannot insist on using the single language in the working environment? This might be beyond the scope of law, so I'm not sure that's a question. that we can answer, but I don't know if you have any ideas to share.
Certainly. I mean, I think as HR professionals, something that we want to be mindful of is that we've got to meet employees halfway, right?
Yeah.
I mean, if this individual is being disciplined by a group of managers who, again, I'm not picking on Romania. It's just the first one that popped in my
Just the
head,
first
right? So
R that came
just,
to you. Well, you're such a globe trotter, Tushar. You're like from I feel like you've lived in all places of the world. So there's
oh
a good
yeah.
chance you lived in Romania at one time
I
as
would love
well.
to visit at some point, right?
Yeah.
But no, yeah, that's one of those things. And do we want to speak with the management team? And I do think that we have grounds for speaking with the management team and saying to them, look, um, communicating communicating regarding business matters in another language, although it might be easier, makes the communications inaccessible to other members of the team that should be aware of these communications, provided that, of course, they're business related. If they're talking about, my niece's quinceañera,
Yeah.
then hey, go for it. If you're on break at lunch, etc., that's fine. But if the circumstances that are giving rise to this are related to discipline or performance management or stuff that is eminently work related, we're actually excluding the person from a conversation by flipping to another language, particularly if we can speak both, right? So it's
Hmm.
actually a
Hmm.
form. So excluding someone deliberately from a conversation is a form of harassment in and of
Hmm.
itself, right?
Hmm.
There's good solid case law to justify that. So I think that should give you, Janelle, the legs to stand on to approach those supervisors, managers, and say, hey, we don't want this to continue. We're putting you on notice that if you continue excluding this individual from conversations that are work related, then we won't have a choice but to implement a process that corrects this, and we could be potentially looking at discipline if they continue down this path, right? Particularly if
Hmm.
they can, again, speak in English and then they just choose to flip to this other language. So, yeah,
Yeah.
no, thank you for the follow up. That's really helpful clarification.
We just have a few more minutes to answer a last question here. This is an interesting one. How should an employer handle a situation where an employee raises a harassment complaint during their 3-month probation period and subsequently resigns? There's more. During the internal investigation, it emerges that other employees felt threatened by the complaining employee. Now the resigning employee is requesting to relocate to another office location. To add to this, the HR personnel who was investigating the case went on vacation and is no longer working with the company.
This is like a law school exam, right? Like this is
Yeah, it is. That's
this
a
is like
quite that's
this
a
is a
it's a
fact
very good
pattern.
question, but it is quite a meaty question.
And I get the sense that we can't possibly make this stuff up. I mean, I'm sorry that you're having
Right.
to deal with all of this because
Yes,
it's
me
a
too.
bear, right? So
Yeah.
the employee raising a harassment complaint during the 3-month probationary period, the complaint presumably would have been in writing and would have started a formal process, right? So I think it's incumbent on us, as per, again, assuming we're in Ontario or even federal jurisdiction in another province, let's tick the boxes and wrap up the investigation. And if the person quits and then they don't participate in the investigation itself, they could that could be an adverse finding of fact in the context of the harassment investigation that you have to then go on and complete. So that's, I think, hopefully that kind of covers the first one. So it emerges that other employees felt threatened by the complaining employee. Threatened is tough because is it a formal complaint? Is it something that they just mentioned? And we have to
Hmm.
sort of use that threshold of is it an actual formal complaint yet? And if it is, then fine, we will add that to the scope of the investigation. If not, or if they just mention it offhand and they don't want to be involved, which does happen a lot, more often than you can
Hmm.
think. But yeah, if they don't want to be involved, we can't really do that much there
It's not a
because there's no
formal
witness.
complaint. This
Mhm.
is the thank you for adding that. Yeah. Hmm.
Got you. Okay.
Yeah.
And so it's not a formal complaint. So what do we do there? I think we focus on the first one, right? And then if there's an adverse finding of fact or the person just drops this bomb and then decides to leave while the door is still swinging, and then throws the Molotov cocktail at the bridge to
Yeah.
burn it while they're walking across,
Yeah.
then yeah, we can have adverse findings of fact made based on their conduct because the investigation wasn't over by the time they resigned. Um, and then okay, the resigning employee who has quit, uh,
Yes. Wants to move to another office
if we've accepted their
location.
resignation,
They're gone. Yeah, that's
Do not
probably,
allow them back into the
yeah.
building. We do not want
Mm-hmm.
this person anywhere near the place.
Yeah.
You know, if you were stuck on a desert island and there was only one other employee who could work for your company, I would still say no, because they're
Yes, I
gonna,
think
again,
so.
with the burning of the bridge example.
Yeah.
And the HR personnel who's investigating the case went on vacation and is no longer working with the company. Unfortunately, the Health and Safety Act just says appropriate in the circumstances. So you have options. New HR
Yeah.
person, that might be you, anonymous attendee. I'm so sorry. We'll have to pick up the pieces and either restart or finish the investigation, right?
Yeah.
And we'll have to put a bow on it. We'll have to finish this up, or
Yeah.
go external, right? I mean, that's the other option. Amy, I know we have just a wee little bit of time left,
Yeah.
but I just wanted to maybe put this out into the folks that are in the chat, because I think it's relevant to harassment, and it's something that's kind of, it's near and dear to me, and I
Mm-hmm.
think once you hear it, it'll be near and dear to you. Something that my colleagues here at Gowling, and we've spoken with management side lawyers at other firms, that we're getting a lot of inquiries about, let's say, or conflict checks, or just in getting involved in these types of cases, is we are starting to see harassment investigations specifically, or accommodation requests that are denied, or whatever the case is, some sort of friction that's happening between management and a specific employee, with a negative outcome for the employee. And it might generate a common law wrongful dismissal complaint, or a constructive dismissal complaint. It might generate a human rights complaint. It might generate an Occupational Health and Safety Act Section 50 complaint, a reprisal
Mm-hmm.
complaint. It might generate some other form of complaint under the established processes that people usually go to when they're trying to deal with these issues. Those are well known. There's enough there to think about. To layer on top of that now, something that's alarming that I've been seeing is that they are going into the regulatory body code of ethics and conduct, or code of conduct policies, and they are filing regulatory complaints against my clients. And
Mm-hmm.
they're filing them with the HRPA. They're filing them with
Right.
CPA Ontario. If we've got a
Yeah.
director of finance / HR, sometimes they're not just an HR person. They could be a chartered accountant,
Yep.
going above our clients, and basically trying to threaten this individual's
Hurt
ability to work,
to
right? Get a
work. Yeah.
suspension, or delicense them. So
Yeah.
take away your CHRP, for instance, right?
Yeah.
Just if you can pop something into the chat for those that are listening. Have you dealt with this? Are you aware of someone who's dealing with this, and are you seeing this as a trend? Because that's what we're seeing on the ground here.
Yeah. I can't right now, but it's definitely worth something exploring for sure. But sorry that I have to wrap up, but thank you so much for everyone who joined. Thank you. I wanted to quickly introduce Margot, who's in the chat. I'm really super excited. We're running a session that's coming up on May 8th, and Camara is going to put in the link to register for that session as well. It's all about doing mastering reference checks. So please check that out. If you want to chat to either Tushar or I know Tushar, you put your details in the chat. Camara has put my details in the chat as well. You're welcome to connect with us on LinkedIn. And like I said, if you want to talk to me about outplacement or onboarding, there will be some follow-ups coming your way, including information about that, but also we'll invite you to the next session next week, but you will also get the replay of this section. And sorry, Tushar, for having to cut you off. I know that people have to go to their next meetings. What you did bring up, though, is very, very important, because it's one thing when we make a harassment complaint, or when there is a harassment complaint against the Goliath, which is the company, right? And technically speaking, in most cases. But it's a very, very different thing when it's against the individual and will affect their ability to pursue their career in the future. And also when it's done in bad faith. And I think that's what you're getting at too. It's like, well, you're going to file a harassment complaint against me. I'm going to file a complaint against you that's going to hurt you as well. So I think that's a really important one. I think it's one that we should have another session on, actually, Tushar.
Absolutely.
And in that case, it would be really great to find out the data behind how many people feel affected by this. But in the
And how to deal
meantime, I
with them
don't
when they
know.
come in. Yeah.
absolutely how to deal with them when they come in. And if anyone's been in this position, I am so sorry that you've been in that position. That's a very, very tough one. But I want to thank everyone for joining, for asking questions, for getting involved and engaged. Nina, we missed you if you watch the recording. But we will see you again. And I look forward to connecting with all of you soon. But thanks so much, Tushar. You were amazing as
Thank you,
always.
Amy. Thanks for having me as always, and hope
Yeah.
everybody has a great day.
Oh, thanks. I love that I leave these little icons on now and people are sharing their little
That's
hearts
a
and
new thing.
likes
I
and
absolutely
aw,
love it.
that's
Yeah.
very nice. Thank you